When the screen goes dark and the world won't start, you know who to call, yeah. Watching you struggle with that frozen screen. 3 days now and you're losing your mind. I see it typing and nothing's working right. Daniel's got that look in his eyes. From sunrise to the end of the day, you're always fixing what's broken away. Why do you always stay when everyone else would walk away? Why do you always care, Daniel? Why you're always there? Coffee's getting cold while you run diagnostics, explaining every step like I'd understand. Your hands move fast across the keyboard magic, making sense of what I can't comprehend. From sunrise to the end of the day, you're always fixing what's broken away. Why do you always stay when everyone else would walk away? Why do you always care, Daniel? Why you're always there? Maybe it's not about the broken parts. Maybe it's about the way you see. Every problem has a beating heart. You won't give up on me. Now the screen's alive and everything's running smooth. You pack your tools with that quiet smile. I know tomorrow when something breaks loose, you'll be back here in a little while. That's why you always stay when everyone else walk away. That's why you always care, Daniel. That's why you're always there. When the screen goes dark and the world won't start, I know who to call, yeah.
Well, welcome back again. Today is Monday, which means we're back on the regular schedule for this week, which means it's Judge Fleischier. Now, please understand that I can't be watching the chat and watching what is being presented to you. I have to watch what's presented to you because ads with music keep getting this channel struck. And I'm having to go back and have to remove that section of the video. So I think what's going to happen is when ads come on, stop it, mute it, and let it play. So I have to be concentrating on what I'm doing. I can't concentrate on what the chat is doing. That's why I depend on the moderators. That's why I depend on the moderators. Moderators, please just watch the chat. If you see something inappropriate, warn them the first time. Second time, put them in a timeout. If it continues, then let me know and I will ban them from the channel. Oh, I got some exciting news. I'm working on something that's really, really good. So I will let you know in the coming up weeks what's coming up. This is going to be really good. I think it's going to be beneficial. So today is Judge Fleischier. I love Judge Fleischier. So let's get started here. Share screen. Share this. Make this bigger.
I missed because of school. I just forgot to
Last Friday. Why did you miss court?
the school, and it just slipped my mind.
How old are you, sir?
17.
Okay. How'd you get here?
I drove.
Okay. You're charged with tampering. You're facing up to a year. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Officers initiated a traffic stop, observing the defendant's vehicle run a stop sign in Harris County, Texas. The officer asked for the defendant's driver's license, and the defendant provided it to the officer. When the officer went to verify the driver's license, the number came back to a Leslie Salazar. The defendant admitted to the officer that his driver's license was fake. The defendant then provided his legitimate driver's license to the officer.
Why? Don't say anything. Do you have any indication? I mean,
I'm not entirely sure, Judge. I don't know if it was like a mistake or to hand over the.
no, fake ID, I see. Did they take it? Do you know if they confiscated that license?
I believe they did. They have a photo of it. What the officers took.
Ready to win big with Zinn?
Well, she's taking. Mr. Brock, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license? Do you have valid liability insurance in your name?
I'm assuming so, or in my mom's name.
Don't assume anything. Never assume anything in life, because if you get into a wreck and you kill a 5-year-old kid, they don't care whether you make assumptions or not. The only question is whether you do or not. And if you don't, then you're not allowed to drive. And I'm making that a condition of your bond.
Yes, it was taken.
Wonderful. I am making it a condition of your bond that you're not to have any fake IDs, fake licenses, or anything of this nature. And if I find that you're using that, or you're trying to get booze, you're trying to get illegal drugs, I will put you in jail. You will not get any PR bonds. Do you understand?
Sir.
Life is really going to suck. At 17, you going into jail. Let me tell you what kind of field day the people in custody will have with you. Do you have any clue what they will do to you in custody? Take a guess. Imagine your worst nightmare. It's worse. Get my drift? If I drug test you today, what are you going to test positive for? And beware that you're going to get tested. Anything else? I'm sending you for a test. You're to go test and you're to come right back. If you fail to go test, if you fail to come back, I will put you in jail and I will revoke your bond. Do you understand? I will appoint you a lawyer today. We will talk about that when you get back, but I want to know what, if anything, is in your system, and we'll go from there. What are you doing now with your life? Are you in high school?
Sir.
Okay. Senior, junior?
Senior at Memorial.
Okay. What's going next? What's happening next?
College, UT, or LSU.
You sure? Okay. Let's see. You got to understand, this is not a good start to your college career. This is, in fact, about one of the worst things that you can do, because all career services, all schools, they're going to look at this. And this can really impact you for the next 40 years of your life. So go take a test, come back, and then we'll talk further, okay?
Now, were you stating, Your Honor?
Oh. Have you played Monopoly before? Okay. In Monopoly, you get a get out of jail free card. This is the only one that you're going to get from me. If you ever miss court again, if you ever fail to come when you're supposed to, I will issue a warrant, and I will keep the warrant, and I will lock you up.
Sir.
Do you understand? No more get out of jail free cards.
Judge, you said no, fake IDs or licenses for bond commission.
Don't worry about it, because I'm gonna,
All right,
Yeah.
Judge, the next.
oh, what? Did you think that you were coming to the beach today in shorts?
Yeah, I'm sorry. I completely wasn't using my head.
You know, when my kids tell me sorry,
It's my first time in court. I'm sorry.
it's a court. You know, in court, you're supposed to dress a certain way. This isn't the circus, man. You know, you continue to say sorry for things. At some point, your sorry will go in this ear and will go out that ear. Do you understand?
Sir.
Everything you're doing here, I'm going to mark it and we will know it. So that if you come in here and try to play this game again, I will put you on my knee like a little child and I'm going to spank you like a little child, but I will do it with a ton of jail time. Do you understand?
Sir.
Good morning, ma'am. Ma'am, you're charged with, please spit the gum out. Do you have a trash that she can spit the, so you're not smacking like? Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Officers observed the defendant driving a without lights on at night. Officers used the intercom to tell the defendant to turn her lights on. The defendant pulled over into a parking lot. Officer approached the defendant to ask why she did not have her lights on and observed strong odor of alcoholic beverage. Officer detained the defendant and placed her in the back of the patrol vehicle to wait for a secondary unit to assist. When officers returned to the patrol vehicle with backup, defendant had slipped out of one handcuff, and while officer attempted to place her back into handcuffs, defendant bit one officer and kicked the other. Defendant was taken to JPC and a blood warrant was signed and executed.
They didn't, I guess, because of that, they didn't do any field sobriety tests on the scene. They didn't do any at the station, I guess, either.
Right, Judge.
Okay. Ms. Barros, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I will randomly test you. If I find that you're using alcohol or illegal drugs, I will put you in jail. You will not get any more PR bonds.
Yes, sir.
Do you have a valid Texas driver license, ma'am?
No, sir.
Then you're not allowed to drive. I'm making that a condition of your bond as well, and you're going to sign with me today a promise. This is an affidavit that you're going to sign that you're not to drive any vehicle whatsoever for any reason, and I don't care what your excuse is. If you drive, I can have a contempt hearing. You can be facing 6 months in jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
If you want to drive, go get a license, get liability insurance, show us that you have this, and then I'll happily take this restriction off. But until that point, if I find that you drive, I'm going to go nuts on the bond. Do you understand? Okay. So you have a lawyer. It's your responsibility to stand to Mr. Brooker, and he'll tell you when you have to come back to court. If he tells me he can't get a hold of you because you're ducking and dodging phone calls or text messages, likewise, I'll issue a warrant. No more PR bonds.
Yes, sir.
Okay. I'll have you come up here, swear to us that you're not going to drive. We'll have you sign a reset with Victoria. You'll meet with Felicia for your bond conditions, and after that, you guys are free to go.
Thank
All
you,
right?
Judge. Step over here. Thank you, State.
Thank you.
John, come on up. He did re-enroll in school, Judge, as instructed.
So are you appointed or are you retained in this case? Is mom here as well?
Yes, yes.
Come up, mom. You can come up.
Judge, for Barrows, did we have any special bond conditions for Barrows?
Same as normal with the DWI. And then she's here in shorts, man. I'm going to talk to her here in a second.
I'll speak with the judge.
No more marijuana. Do you understand? I will test you 40 to 45 days from today. If you test positive again, that tells me that you've continued to smoke. I'm going to put you in jail and I'm going to make your bond high. You got to understand, your mom probably doesn't have a lot of money as it is. Every time you go to jail, it's going to cost her money to get you out when she could be feeding and using that for rent. Do you understand? You are also to stay in school, not hang out with the people that you were in this car. No associating with the co-defendants in this case. No weapons. Stay in school. Do you understand?
If the roof on your home has a leak or has missing shingles, that's an incredibly frustrating situation, but it's
We've now given you a lawyer. It is your responsibility to stay in touch with counsel, and he will tell you if and when you have to come back to court. If he tells me he can't get a hold of you because you're playing games, I will issue a warrant. And I'm going to tell you now, I'm not going to give you any more PR bonds. Do you understand?
Yes, sir.
Okay. Anything that you'd like to add? Do you need anything? Because I don't know how he is when he's at home with you. Does he act up? Does he help you out?
Yes, he helps me out. He does side jobs at home. Recently, I was able to get him enrolled back into his homeschooling program, so he's actively working on it.
Okay, I'm going to want proof that he's actually enrolled in school and actually doing well.
You can provide it. It's online.
Great. And I'm also giving him a curfew because I don't want you out in the middle of the night. You're getting a curfew at 10 p.m. and I'm putting a monitor on your ankle so I know that you're not out. Do you understand?
Sir.
Don't act a fool. You start being a danger in the free world, I will take the free world away from you in a second. My only concern is public safety. And when you're in a stolen car with a bunch of other people with stolen guns and everything, it's not a good look. All you're going to do is end up with a number on your back, perpetually in and out of jail, never amounting to anything. That's not a good way to go through life. Life is a journey. It can be a great journey where it's filled with love, fun, vacations, nice cars, or it can be a miserable, rotten toilet of an existence where you never have any money. You argue with everyone about everything because you ain't got no money, got no education to be able to support yourself. That's not a good way. That you don't go through life like that. And it starts now at 17. You understand, Mr. Melendez? You won't get any more warnings from me. Straighten up and fly right. You stay with me. Okay, guys, thanks.
Thank you.
We will pay for everything for you, so it shouldn't be a dime out of your pocket, okay? All right, Mom, thanks. Please, Samantha Walker. Ms. Walker, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge.
Okay.
On November 4th, 2024, an officer was dispatched to a family disturbance call at a residence in Harris County, Texas. The complainant, a 15-year-old, stated that the defendant, her mother, assaulted her after they got into a verbal argument. The complainant stated the defendant displayed verbally aggressive behavior towards her, grabbed a hold of the complainant's left wrist, and said, "If you come near me, I'll beat your ass," and began to engage in a physical altercation with the complainant. The complainant stated the defendant, using both open hands, placed the complainant in a headlock and the complainant felt pain. Both law enforcement and CPS records indicate a history of physical altercations and verbal altercations between the complainant and the defendant, and the officer observed video footage showing the defendant acting as the primary aggressor towards the complainant and observed a minor injury cut on the complainant's left arm.
So we have prior violence, any prior charges?
There's no prior
And
charges,
no
Your Honor.
prior injury to a child, felony charges?
No, Your Honor.
No. Okay, so you take all this stuff.
Child means 14 years or younger. Okay, ma'am, I'm going to find that there's probable cause to go forward with your case.
No, Your Honor.
Don't. Now's not the time, ma'am. You have the right to remain silent. Exercise that right. I've got a bunch of DAs here. Anything you say, they're going to use it against you. Guys, what do we do about contact? You know? Yeah, well, so Michael, I need your help. You know, this is a 15-year-old child. we have a history of violence allegedly between mom and daughter.
Yes, Judge.
Now we have an assault case against a 15-year-old. And according to what Alex says, there's a history of it. It's unacceptable.
Judge.
Do we have a lawyer, ma'am?
I'll be retaining a lawyer, but there's no history of violence between us.
You're calling for a walker?
Yes.
Which walker?
One Walker.
It's in custody.
Oh, thank you.
Okay.
So, what my plan was, and I already spoke to my people about this, is we were gonna check the offense report to see where the child was taken. Were they taken to CPS custody, state custody? Was there some other guardian? Once we're aware of where the child is, we are gonna be asking for a no contact order to be granted based off of the allegations of the history.
What
of
about now?
violence.
Is there something that we can do now as far as finding out where the child is?
Well,
You know?
we're gonna call CPS today and see if they're in state custody. The offense report also might indicate where it is. If not, we can call the officer and they should know.
Yeah, I'd like to, because I think it's serious. I mean, if we have a history of violence, I don't want that to happen anymore.
There's no,
I know that you're telling me no, but I have other people that are telling me differently.
I've never.
Okay, well, ma'am, don't. Now's not the time. But my primary concern is the protection of every single person in Harris County, bar none. That's it. Especially if it's a child. And
I'm not a threat to my child, I promise you.
you are now charged with assault, ma'am, on that 15-year-old child.
I never assault.
Stop. Now's not the time. I'm just trying to tell you, if I find that there's a history of violence with the child, I'm going to order you not to have contact with this child.
I understand,
As it stands now,
but I promise there's no
I'm entering
history of
in
violence.
called a magistrate's order for emergency protection that identifies EJ as a protected individual. You
I
cannot,
have to take her to appointments and stuff like that.
please listen. Okay, I know that you're trying to think of stuff to say,
No,
but
I'm
I
being
want you to
honest.
listen because this is very important stuff. And if you don't hear it correctly, you do something to violate this court order, they're going to file additional charges against you. I'm entering in an order for protection for that 15-year-old child. She's now a protected individual. You cannot commit family violence or an assault against this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon. Typically, this also comes with a residential restriction that you're not to go within 200 feet of where she lives or where she works. You understand? Okay, I'm entering this order now. We will try to figure out about how we go from here, but my only concern is the protection of this child. To me, nothing else matters.
She's protected.
I know that you're telling me one thing, but the evidence will show what it shows, and that's going to point to whose side is correct. So for now, I'm just going to have them reach out to see where the child is and how we go forward. So for now, I'm going to have you sign a reset, and then we'll just have you take a seat in the jury box, please. Okay?
Three.
Your Honor, I'm here on Leo. Leo's the last name, Leo Terrence. And he's here today, Your Honor. This was rolled over from yesterday. And we have an issue on the PTI. We need to bring to the attention of the court. There was some
Leo.
violation. Yes, sir, he is here.
Come up, Mr. Leo.
There's some issues, violations. Mr. Nathan is PTI chief is willing to agree to extension of the PTI. He had just almost about to finish it when the violation occurred. But they're willing to agree to a 6-month extension. We're before the court today to request to see if the judge will agree and approve that 6-month extension on this PTI. I'll let your staff here advise you of this violation.
A lot of it depends on how he was doing Has he done anything? Has he done most of it? What are the hiccups? Is he continuing to use?
Yes, sir. In that regard, he is scheduled for two classes. One is being November 13th, what are the 2 dates?
November 13th, 15th, 6 p.m. to 9, and second class is on December 2nd, from 6 to 9. That's virtual.
So those are the two classes they had set him up for.
What has he done?
He has to complete the DWI education course and the effective decision making. Those are the classes he's registered for.
Well, he hadn't even done that, and it's
So he's kind of financial hardship, so they're doing all of the programs in-house. His device has been in lockout since July.
well.
They've been drug testing him more frequently because of that. His last 1, 2, 3, 4, 5 drug tests were positive for marijuana.
You don't say. If I test you now, what are you going to test positive for? Really?
His last
Really?
drug test
I'll
was
send you right now. We'll see.
His last drug test was October 16th, and he was positive for marijuana. So they want to extend him for 6 months to allow him to complete the 2 classes in Iowa.
Joe, he hasn't done anything. All he's done is continue to smoke weed the whole time.
Your Honor, I did sit down before we approached, and he assured me that he had stopped. I told him, talking to you, and that you would test him, and, I gave him the option because, I was willing to speak with the DA too to see where they wanted to go with this and talk with the client as well about that. One of the things about the machine, he says, as you said, he's been out of a job, and the probation officer's working on him knows that, and that's why he hadn't been able to pay for the installation of the
But he
machine,
has
which is no
enough,
excuse.
but he has enough money to smoke weed. People spend money where they want to spend money, right? If you truly want to do something, there's always a way. So when someone is not working, it's because they choose not to work, not because they can't work. If you really wanted to work, you could. It's a matter of you just don't want to. And I get it. But don't come here asking for us to be lenient when you don't do anything. You've been in lockout since last July? You've been in lockout for an entire year. And Joe, if I send you for a test right now, what are you going to test positive for? Man.
I ain't been smoking the whole October.
Look,
I
just
have no marijuana or nothing. I don't do no other drugs.
no, you're in a diversion program where the idea is you're supposed to stay clean. And when you do, the reward is that they dismiss your case. And if you do, you don't even have to do that much. All you got to do is 2 classes, right? And just stay out of trouble. And they dismissed the case. Joe.
Yes, Your Honor. Your Honor, I wanted the opportunity that if
he's been in lockout for an entire year.
I was going to talk with the DA and see if there's another resolution of the situation and see what options. He wanted me to check on that. If the court was not in, I explained to him 6 more months means he needs to be in compliance 6 months.
Yeah, I'm not, and he's not been in compliance at all for anything. I'm not inclined to do another 6-month reset for him to just do nothing for another 6 months. I mean, we're delaying the inevitable. You know what I mean?
Yes, sir. I understand.
So you might as just.
Yes, sir. Your Honor, we'll talk to him right now, and thank you for the opportunity to come before you.
Sure, Joe. I love you, man, and I'd say that of all the people that come here with violations, 99% we do. But you got to show that you want it, that you really have a willingness to do it.
Yes.
And when you don't, really, I mean, the program is designed to reward people who faithfully work for it. And I get that there are hiccups in life, but when you do nothing, you've been in lockout for an entire year, you literally have done nothing for an entire year, and all you've done is continue to smoke weed the whole time. That shows us you don't care. So why would we care? All right, you guys talk. Let me know what you want to do. You must either accept or we're going to set your case for trial today. Okay? All right, please.
I want to have one other one, Brenda Reese.
Sure.
The court had asked me to approach on this one. This is a client who's also working toward dismissal. He just needed one more reset in order to get the funds to pay for the driver's license. which is the
Yeah,
last
I mean,
part.
it's 140 days. If you need more time, of course.
Your Honor.
Yeah, for sure. Whatever you need,
Thank you very much.
of course. Mr. Elick.
Your Honor,
Hey.
I'm Samantha Walker, and
You guys ever get a call back?
no, Judge, we did.
Imagine being able to build an app with your name.
So, Judge, I met with the defendant with defense in the room.
Oh, okay.
I'll let defense.
Your Honor, I showed him some video of the alleged assault, I believe. Of course, I haven't gone through the state's discovery, but this, in my opinion, is a child out of control. She's on juvenile probation in Tarrant County, according to her mother. The complaint says that she caused bodily injury by grabbing her. I mean, the complaining witness has a statue. She's threatening to get a knife. She's bigger and stronger than my client. My client's called the police numerous times.
This is why we appoint.
And so
There's
I
always
think-
two sides, right?
I think
Always
this
two sides.
is almost enabling the child when the police come. The police saw all this, but they're so sick of going out there. They're like, we're somewhere.
But I don't understand why they wouldn't, if you see this, Michael, did you see it?
I saw the video, Judge.
Okay.
Based off of what I saw and what defense told me, I'm unopposed to removing the residency restriction, to not granting a MOAP at all, and to just.
No more.
I wouldn't.
Okay, I mean, if that's what you think, I'll go with what you think. I
Based off what
think,
they're telling me, Judge, and I did corroborate some of the information as well. We're just going to subpoena the CPS records to take a look.
come up, Ms. Walker, come up. So I guess, the $25 million question is, how do you wrangle in a child who's out of control?
I've been doing everything in my power to love her, do everything to help her get some type of mental help. I've had her admitted to several programs. I've even contacted CPS myself personally, had them come out to the house. She got up and walked out on us. I've tried therapy. I've tried medication.
Hell hath no fury as a scorned 15-year-old. I tell you
None.
what, I mean, I
None.
remember I was 15. Oh God. And I hope it doesn't, I mean, I know it's going to happen to me, but what's she on probation for?
Trying to stab her older sister, my other daughter,
And that's in Tarrant County
in Tarrant County.
and a juvenile case.
Another felony.
Okay, so I'm at your disposal, I guess, whatever you want, ma'am. I'll take off I won't do the order for protection. Just be careful, I won't put I'm not going to put any conditions either, I guess,
I would just say no threatening or harassing, Judge, if the court's inclined to do that. This is some sort of.
I mean,
safe
how do you handle a 15-year-old? It's,
How can you be a parent if, it's almost like you're disarmed and the child can do whatever she wants. And if you touch me, well, then you're going to jail, Mom.
Correct.
F you.
No, I mean, imagine that. The child will have unfettered access to.
And the
Just
arresting
wreak
officer
havoc.
told her, if you feel triggered, you can leave and take a walk. Well, that walk turned into her being gone for 7 days.
My Lord. You can bring her here?
Huh?
She'll come here. I can try to talk to her,
Yeah,
show her the jail. I don't
she's
know.
been to jail in Tarrant County already because she continues to violate.
Well, that's the juvenile detention, it's not the same thing.
I don't know. I mean, I don't know how worse juvenile detention is versus regular.
And she had an ankle
It's-
monitor, but
I'd
it was
imagine.
cut off.
It's not like the jail.
Really?
Yeah, they're in plain clothes, they're not in handcuffs, they have plenty of hours.
Really?
It's completely different.
It might as well be a playground.
Yeah.
Wow.
It's not like Dr. Phil where he sends
No.
them to the.
No.
Okay.
It's a playground.
I'm not going to put any, just be careful. It's evident she's bringing you down too. And I'm so sorry for it. You're welcome to come bring her here. We'll try to help you out.
Yes.
If she'll listen to me, I'll try to talk to her or whatever you need. We're at your disposal,
Thank you. I appreciate that.
You ever need funds for anything, just let me know.
Okay.
That's why, I wanted to appoint you someone because there's always two sides, right? We get one side here, but a lot of times you don't get the other side. And a lot of times we take that for granted. And it's good to have another ear in, just so that we always know, we get a complete picture, and it's just so important. So I'm sorry you're going through that, and I hope it gets better. You know, if you keep loving, I got to imagine she's going to get better, really. Because I tell you, I was the same way. Hell on wheels, you know, and if it weren't for my folks, holy moly, I don't know where I would be, you know, really. So, okay, man. Thanks. So we've given you a lawyer. Just stay in touch with James. He'll tell you when to come back, what you need to do. I'll waive your appearance. You don't have to waste your time to come into court. Just stay in touch, and then you guys work it out. Okay?
Yes, sir.
Okay.
Thank
Best
you.
of luck to you.
So the protective order and the.
No conditions,
and
no.
No conditions. Okay.
Just,
Well, just hold on to it, but.
yeah, we'll shred it. Just shred it.
Okay.
Yeah. Okay.
Thank you.
Okay.
Just lapse.
Who would do that plea on Leo?
Okay, of course.
Mr. Leo?
Yeah, Mike did.
Mr. Michael, what was his last name again?
Leo was the last.
That's right.
Terrence Leo.
You know, Mr. Leo, you got into this program, and may not be today, may not be tomorrow, may not be in a year, but one day you're going to kick yourself for not making this work, because now this DWI will go on your record. It will be there for the rest of your life. It's even there after you die. And this is important, because if you ever get pulled over in a car, first thing an officer does is they look at your record. If they see that you have a prior DWI and they come up and they smell weed on your car, they smell alcohol, what do you think they're going to do to you? Right. What we're doing today, from now on, you are facing a minimum of 30 days in jail. No more catch and release. Do you understand? So if you want to get lit, you want to have 52 beers, 32 joints, don't get into a car, because you do, there's going to be a lot to pay. Not only that, but there is a surcharge of around $3,000 in this case that you'll be responsible for. Not to mention the court cost, which is another $500 something. Yeah, when you get a DWI, it's really expensive. You get a second DWI, it's around $7,000 in fines and fees and surcharges. And if you don't pay it, you don't get a license. And you don't get a license until you pay it. So it will be in an indefinite suspension. Do you understand? DWI in Harris County, it's big business. Not only that, it's so dangerous, it's ridiculous. So how do they get you to recognize that? By hitting you where it hurts, in the pocketbook. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen or possible immigration consequence, you can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it will go on your record. Like I said, it'll be there forever. You can never come back and complain about this. Do you understand?
Yes, sir.
How do you plead to the offense of driving while intoxicated? Guilty or not guilty?
Guilty.
I will find you guilty, and I will sentence you to 3 days in jail. I'll give you credit for the 4 that you've done. I'm going to suspend your license for 180 days. Do not drive until you get a license.
What if you can create your own website by...
What are you doing with yourself these days?
Looking for a job.
When was the last time you even had a full-time job?
Last time it's been like 4 months since I couldn't get Ubers back and forth because it was like 40 minutes away, so I couldn't afford the Uber. So they basically let me off because I couldn't show up. So I've been done 11 interviews. I've done a lot of applications as well. I've been just trying to find me a job.
Did you graduate from high school?
Yes, I did.
Okay. You know, the idea in life is that you were young and you bust your ass when you're young, so you don't end up 70 years old without a pot to piss in. Because I'm going to tell you, the older you get, the more difficult life gets. And if you don't have a pot to piss in when you're older, life will be all the more difficult. You work hard, you set yourself up now so that you have a future and that you have a nest egg when you're old, because you're not going to be young and vibrant forever. At some point, your knees start hurting, your back gives out, you get bald, you get fat, you get ugly, you smell bad, you get hair where you never know it even exists and start coming out. It doesn't get easier. And if you don't have money, this life will really suck for you. So you work hard now so that you have money in the future and take vacations. You buy nice cars. People divorce now because all they do is they fight, and they fight about money. That's why half of this population is divorced, because they ain't got no money. Do something with yourself, Mr. Leo. I will give you this now. I will roll your court costs, and I will quash your otherwise $3,000 surcharge. But if you come back, look forward to HE double hockey sticks, if you catch my drift. If you understand, next time it's going to cost you big. Do something with your life. Don't be a wastoid like. Good luck.
Thank you, Your Honor.
Thanks, Joe. Well, you know, Leo, Mr. Leo, we want what's best for you. What you're doing now is you're doing nothing. And you will end up as a nothing. Just smoking weed all day. You got to stop. All right. Good luck.
Thank you.
Thanks, Joe. I'm making your bond conditions severe. I want you to understand, no more fake IDs, no alcohol,
Situation again, promise.
no illegal drugs, and I'm going to test you. I will test you 40 to 45 days from today. If you test positive for marijuana again, that tells me that you continue to smoke. I will put you in jail. You will not get any more PR bonds, and I don't care if you're kicking and screaming and praying to Allah that it wasn't this. I don't care. You will go into custody. You are on notice now. Forewarned is fair warned. Do you understand?
Sir.
All you have to do is stay in school, graduate, don't use.
I know.
Do you understand?
Sir.
Okay, we've given you a lawyer. It is your responsibility to stay in touch with Jillian, and she will tell you when you have to come back to court. If you test positive, or I'm sorry, negative, at that point, we'll just give you a normal reset, but you are still under bond conditions not to use.
Sir.
Because they can call you in at any time to come test.
Sir.
Understand?
Sir.
Okay? All right, Jillian, thanks. That's it.
Hey, Mom? Where are you?
Zigri?
Good morning, sir.
Your lawyers asked for me to set you a bond. You were wanted out of the state for another charge. I don't know you. I've never met you before, and I have to get to know you in a very short amount of time. I know that you're going to tell me it's little bunnies jumping in the woods, but really, I don't know you. My only concern are two. Number one, and most importantly, public safety. Number two, if we give you a bond, are you going to go to the jurisdiction that you're wanted from? So Amy, tell us about Mr. Zigri.
Yes, Judge. He's wanted from Ottawa County, Ohio for grand theft. The amount for the grand theft has to be greater than 7.
Pause here. Did you catch that? We're talking grand theft, not petty theft. In Ohio, that means over $7,500 stolen. The judge's immediate concern is clear. If this guy has a history of skipping out on cases, can he really be trusted with a bond? What do you think? Should repeat offenders even get bail? Or is that just rolling the dice?
2,500, less than 150,000.
Wow, that's a big.
Yes. And as the court knows, he is currently on deferred for that state jail theft. On that state jail theft, he did have a prior bond.
I know, I saw it.
Prior bond forfeiture.
Yep.
Day and I are requesting no bond on this case.
Continue to get PR bonds. It's like catch and release. Is that what we're doing?
No, sir.
He has also other criminal history from Pennsylvania and Ohio for bad checks and thefts. I believe he was previously arrested as a fugitive from justice in August of 2022. He's had bad check and thefts in 2013, 2014, 2022, and 2023.
Okay, so how many thefts are we talking here in total? I mean, that's at least 6.
I'd have to count, to be honest, Judge Fleischier.
Does it stop?
It stopped when I was extradited here and put on probation in Harris County. And I've made all my restitution payments in which I'm current. And I've been doing so since July of 2022, sir. And I have a full-time job. I make now $2,000 a week.
Is this a new case from Ohio or is this an older case? What do you see?
This one was issued from October 18th of 2023.
Okay, so it is older. Well, but this, so you said what day?
October 18th.
Okay, so he gets on deferred in July, and then this case is in October. So 1 month later, he picks up a new case.
No, no, sir. The actual case was from January. I was extradited. I posted bond there, and I was extradited to Harris County, directly out of Ottawa to here. And that's what I've been on probation here for. This is not a new case, sir, at all.
I will say it was the warrant that was issued, so.
Yes,
not the case, but,
and from what he had said, I'm sorry, go ahead.
no, you can finish. Like,
Sorry, from what he has said, he's not been able to leave Harris County to go to Iowa due to his probation conditions to take care of this case. So that's pretty much why he's here now.
So I missed it. I zoned out. Say it again.
Sorry, Judge.
No, it's my fault.
From what I'm being told, Mr. Zikri was not able to go to Ohio because of probation conditions to take care of the warrant. So that's why he's in this condition today.
I gotta imagine that if he asks his probation officer, hey man, I gotta go take care of this warrant, and they go ask the judge, then perhaps that they would give him. But, my main concern, Ms. Oko, is that, if I send him a bond, whose money is he going to be paying it from?
This judge, he does have a full-time job.
We've got a ton of theft cases. So who else's money is it?
Judge Fletcher, I also forgot to mention, he does have, open warrants as well that are also.
Somewhere else.
Also in Ohio, yes, I forgot to mention that.
It's all on the same case. There's 2 warrants. There's 3 cases pending, a misdemeanor and 2 theft cases. Yes, sir.
Sorry, dude.
Okay.
It's time to pay the piper, man. I can't,
I have not been running, so that you know, I've been reporting to probation. If you look at my Harris County, I've been reporting to probation, making $1,000 monthly payment on that and working full time. So I have not been running or absconding in any which way.
And I think our main concern is we always want people made whole, because
That's what I've been trying to do, Your Honor. Honestly, like if you look at my probation record.
Really, it's okay. It's neither here nor there. I don't know, Ms. Oko. I really have a concern that he doesn't have any money. Where is it going to come from? Someone else's bank account other than his,
Understood, Judge.
Tell me something, Ms. Oko.
From what he stated, he does have a full-time job. He takes care of his sister who is disabled at this time. So he's making restitution payments. So from what I'm hearing, it's as if the time has given him opportunity to do things right. Right. At the end of the day, he's not good at stealing because he keeps on getting caught. So I do think that he's doing things right now, which is why he's not getting caught, because he's not doing anything wrong from what I'm hearing.
Here's the deal. You are an inherent flight risk because you've got all those open cases in another state. So when we set you a bond, if we set you a bond, you're going to have to pony up probably 100% of it. There's no 10%, there's no 20% on these types of cases. You're going to have to pony up all that money. And we're talking probably somewhere in the neighborhood of around $6,000 to $7,000, $7,500.
Okay.
So, I don't know if you have that kind of money.
My company that I work for, my boss, can help me out, and my wife is here. She can help me out, and I have savings that I've worked for, that I've saved.
Like I said, Your Honor, once again, he's not a good.
I just ask, please talk to my probation officer.
I'm not going to talk to your probation.
Okay. She knows where I work. I work for.
Who do you work for?
This weird Japanese trick shrinks your belly fast.
This is the gelatin recipe that took me from 176 to 198 inches just 2 weeks. And
so I guess,
This is classic courtroom reality check. The judge is basically saying, why should we let you out so you can spend your money when Ohio is already waiting to pick you up for free? Notice how he frames it, saving resources and cutting excuses. Smart strategy or a little too harsh?
I guess talk to the family, see if they're willing to pony up $7,500. What I would say is, that money should be used to get a lawyer in that other jurisdiction, because all you're doing is you're basically getting out. We give you 2 weeks to go turn yourself in, whereas we could probably have them here within the next 2 weeks to come get you and take you back there for free. and using that money to hire yourself a lawyer there, right? You're going to deplete your savings.
Just have not come twice. I've been pulled over. Twice they've declined to come get me, Your Honor. And I just been sitting here. That's why.
Is that
I was
right?
just in Brazoria County, ma'am.
He was just in Brazoria County to get a conviction over there.
Yeah, I just handled that, paid $2,900 and settled that case out. Those are all my.
So has he been given a bond before?
In Harris County, Judge?
No, but I mean, he's saying that he was arrested on this very same thing in Brazoria County.
Yes.
And now we're here again.
They let me go. They didn't come and get me.
So it was your responsibility at that time to go up to Ohio to take these things.
They didn't come get, yes, they didn't just, they,
You're not understanding it.
I didn't have a chance to speak to my probation officer. I just
Has
spoke.
nothing, well,
I needed jurisdiction from the judge, Your Honor. That's what I just got to go up, to go travel, to go and handle that case. Because I'm done running. You know, I'm not running, but just constantly, every time I get pulled over, they arrest me. I sit 14 days, 20 days.
So Judge,
and then you know what? And that's a great point. If I set you a bond now, you still have the bond condition from upstairs that you're not supposed to leave. So
from where?
From upstairs.
I know.
You're telling me.
Yeah, she gave me the opportunity to go up there. After I got out of Brazoria,
There's now so many inconsistencies now. When did you get the opportunity to go up to Ohio?
a week ago. I just got it because I just got out of Brazoria. They just released me out of Brazoria not even a week ago. I was in court on November the 2nd, on a Friday. If you look at my court date, I was in court on November the 2nd in Brazoria.
Judge Fleischier, Dave said he was going to be up in 5 minutes.
Let me enlighten you on one thing, Mr. Mr. Zegri, that the more open cases you have, the more of a flight risk you become, at least in my book, because when there's more blood out there at stake, you're just more of a higher risk, you know? Dave, please.
Your Honor, on August 22nd, 2022, he was arrested for 2 charges, passing bad checks and theft by deception. He ultimately entered into a plea deal on August 25th, 2022, where he was supposed to serve 5 years of probation. However, he was also simultaneously found to be a fugitive from justice from Solon Police Department in Ohio on August 23rd, 2022. He was released on his own recognizances, but also simultaneously deferred out of Port Clinton.
The understanding that he would go for the new charge?
I don't know, because it was shortly after that he was placed on deferred in our jurisdiction on July 11, 2023. Oh, no, it was a little bit before. Sorry, it was the other way around. He resolved the theft by check, the state jail felony here, then went there to resolve that. But because he already had an outstanding fugitive case, and the fact that he's on at least 3 concurrent deferred, and the fact that he has 2 active warrants, one of which is a probation violation, which hasn't been filed, but if it files, that it would be a pre-signed waiver, which he would have no ability to make bail or bond. And so because of those 3 reasons is that.
So how do you know there's a pre-signed waiver? Or are you speculating?
It's not guaranteed, but the fact that it's a probation violation, I mean, I can call and ask, Judge, if that's the.
No, it doesn't. It's just too much. You know, you're on multiple probations. You're on a probation here. You've now got 2 other cases in 2 other jurisdictions. It's just too much. At some point, we got to say when. We can't. I mean, it just, you got to understand it.
I've just been trying to make it right, Your Honor. I've been paying everywhere. And the same thing with Ohio, the probation. You're more than welcome because I'm making payments there.
You don't have to say anything.
Yes, sir.
The only thing is just don't pick up any more cases, man.
I've been clean.
You don't have a check.
I've been squeaky clean. No checking accounts, nothing. My wife does the banking. I have absolutely done nothing for 2 years trying to stay clean and make it right.
Perhaps, you know, she's the one that should start taking over the finances.
She has.
I know if you want something, you want to get it, just don't.
No.
Yeah. All right. I'm sorry, Ms. Oko.
Yes, Judge. And
Okay.
he'll be keeping his waiver at the time. He won't be revoking it.
Why you should never charge your smartphone at night. 22 years as a cell phone repair.
14 days from.
Has he already waived? Has he already waived? Okay,
Yes,
so we'll
I'm
just
waiving Friday.
we'll keep your waiver for now. And then if they don't come get you within the 14 days, we will release you. But do you have any indication as to whether they want him?
They didn't come from me in Brazoria, not even a month ago.
We can reach out, especially since there's two different counties. I mean, we send out the notices the day we confirm. So today, the fact that he's keeping the waiver, we should know by this afternoon, at latest tomorrow morning. So, I mean, because also simultaneously, if you were to bond out and
you got to understand though, is that even if they don't come get you and we release you, those warrants will forever remain active until you go take care of them. So every single time you step out there, you're going to come here and do another 2 weeks every single time.
I just wanted to pay Harris County because they promised me, the judge told me that when I'm done paying.
You need to go to Ohio as soon as possible to take care of those things. At the
Just
very minimum,
have it here.
we'll post bond so those warrants lift. All right?
Yes, sir.
All right. Good luck to you.
Thank you, Judge.
All right. I'm gonna
Trying to see if you can.
Are we doing what? Are we doing a probation?
Probation, correct.
18 months though, because of that.
Yeah. Will you remind me the last name again, please?
What?
The last name again?
Studios. Raul.
That's it, Raul. So, Mr. Castillo, you're charged with a total of 3 cases. You're charged with a felony theft of a firearm, DWI, and then you're also charged with
Possession, I think.
possession of a controlled substance with us.
Xanax, I believe.
I want you to understand that this DWI is going to go on your record. It'll be there for the rest of your life. Anytime you get pulled over, officers will see your record, which is not that good. And I'm going to tell you, every time you get pulled over, no matter what you're doing, no matter where you're going, no matter who you're with, they're going to harass you because of your record. The record speaks for itself. And they're going to, no matter if you are coming from church and you're dressed to the bells to the nine. It don't matter. They're still going to mess with you. You understand? So don't give them the opportunity. If you want to drink.
Why you should never charge your smartphone at night. 22 years.
Go smoke if you want to do this. Just don't get into a car. How much money have you spent over the course of the last 10 years on all these cases that you've had when literally $20 clicking one button, maybe 30, can take you wherever you want to go. I'm going out on a date with my wife this Friday. I haven't gone out on a date in months, but I'm going to take an Uber because I want to drink like a fish.
And here's the turning point. The judge makes it crystal clear. The days of leniency are over. Any new charge means automatic jail time. Imagine hearing that in open court. Would it scare you straight, or would it feel like the system already gave up on you? Drop your thoughts in the comments.
But I'm going to do it the right way, and that's taking an Uber, right? It's the responsible way. As much as I would prefer to drive, I know that officers hand out DWIs like it's candy on Halloween. So it's easier for me. That's the way we do it. That's the responsible way of acting. You understand? And you got to understand from now on, you ever pick up any more cases, whatever it may be, it's a minimum of 90 days in jail. And on a DWI, it's a minimum of 30 at least. And then with your other priors, they're kicking up to 90 days. No more proverbial slaps on the wrist. You understand? Shh. As part of the agreement, they're going to dismiss the theft of the firearm, the possession of a controlled substance. As part of the agreement, that gun will also be confiscated as well. You understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you plead guilty, you can never change this or undo this. It will go on your record. It will be there forever. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. You can never change this. You understand? How do you plead to the offense of driving while intoxicated? I will find you guilty. I will sentence you to 180 days in jail. However, I will probate that for 18 months. You will do a TRAS, which is an evaluation to see what other conditions you may need. If they assess other conditions, you must fulfill those. You must do thinking for a change, which is a class. You must do a DWI education class. This is a first, right? Have you confirmed that it's true first? Alex, please. 2 victim impact panels. No breath test refusal, meaning that if you're pulled over in a car and an officer asks you to submit to a breath test, you must do it. If you don't, you're in violation of this probation. No drugs, alcohol, guardian interlock, and a $100 one-time donation to Mothers Against Drug Driving. What do you do for a living, Mr. Castillo?
Self-employed as a landscaper.
How much money do you make a month?
Anywhere from 2,000 to 2,500.
Who do you support in this life?
That's myself right now, and I'm actually trying to help my dad. My father, I live with him.
His dad's here.
Say it again?
His dad's here, but and he works with his dad.
Okay, I'm gonna do you somewhat of a favor. I'm gonna roll your court cost, but there is a DPS fine and fee that you're gonna be required to pay. We will give you 2 years to pay it. But you gotta understand, if you don't pay it, there's jail time that comes along with it. I mean, it's gonna end up being maybe like $75 to $100 a month, but you gotta pay it. All right, so I wish you the best of luck. Make this thing work. If you don't, I'm gonna issue a warrant for your arrest and I'm gonna put you in custody. You're looking at an entire 180-day sentence. Do you understand? Do you have a Texas driver license?
No, I do not.
Okay. We need to make sure that he gets a license as well. Okay. You need a license, man. If you're a landscaper, freak, you gotta, don't drive. I'm making it a condition of your bond that you're not to drive until you get your Texas driver license. I want that done within 60 days. Yeah, it's within 60 days, you must get your driver license. I want you today to go there to start doing what you can to get it. I'm not gonna suspend your license here. Do you know what happened on the LR suspension?
I don't think he has a license, so.
Can you
know.
run his license real quick?
I'll see if.
Yeah, it was 4 years ago, the arrest, so.
Yeah, it's not a 2-year agreement plan because it's been hiding.
Okay. Okay.
Hidden inside the wires of every home is a flaw.
The new surcharge.
So George, you give this to your client, will you? This is the driver's license division for DPS. This is who you need to call to figure out how to get your license back. You call them in the morning and say, hey, this is me. I need to get my license. What do I need to do? Because it's been so long, you're gonna have to take the driver's test. You're gonna have to take the written test. When you call them, you call at 7 in the morning. Don't call at 9, don't call at 1, don't call at 2, don't call at 7:02, because you're not gonna get through. The lines are so busy. You gotta call right when the phone line's open, and that's at 7.
7 o'clock in the
And you'll
morning.
get through.
Yes,
All right.
sure.
We wish you the best of luck.
Thank you very much.
Make it work, okay?
Thank you.
Good job, Ms. Reno.
Thanks.
All right.
Have a good one.
Thanks.
Your Honor, Mr. Alexander is here. And I think.
Mr. Alexander over there?
Yes, back
Come up, Mr. Alexander. Is that mom?
Yes.
Mom, come up. Why are you running, man? Nothing good happens when you run. You know that he picked up a new case.
No, he didn't pick up a new case. The case that you have precedes this case, and all of it is in conjunction with this case. It is
Your Honor-
the same.
I believe the case, I don't know if it's filed or not.
Same set of facts?
It is not
Yes.
the same set of facts, but it predates this case.
It involves the same complainants.
Right.
Or the same family, not the
Right.
specifically.
Oh, I remember. It's right.
Offense
It's the
date is
family and it's.
first, allegedly. So it's not like he violated his
Okay.
bond. I just want to get that clear.
So I'm not gonna do anything to your bond. Just, you gotta be careful, man, The thing is that they're gonna issue a warrant at any time. You guys have to be careful. Do you know when, has Michael told
Your Honor,
you?
I've kind of let my client, I saw this come up a month ago or so, and it just has never, it's still been in the same kind of not signed status. So
We had this exact same situation happen earlier this morning as well. And with that case, they're taking it to the grand jury tomorrow. Hopefully we can get that done with this case so that you guys can get notice of when it's going to happen, because what you don't want to happen is at some point them issuing a warrant and you guys are in a very bad position. An utter disaster. So the quicker you guys take care of this, the better it is while you're here.
And Your Honor, I'm not, the state doesn't really want to do anything with this case.
Yeah, I get it. I understand.
I just would like a reset and.
I know, but I want him to work out the case upstairs too.
I understand.
At his best.
I understand.
Michael,
Yes, Judge.
can you look at Mr. Alexander? The exact situation about the warrant not being signed, we have another one of those right here now.
Right.
With that case, they're taking it to the grand jury tomorrow. Can that happen with this case? Do you know? So that we can all take care of this at one time? I'm trying to prevent them signing it at a later date when they don't know about it, and then it just exploding.
I can check for him too. If he texts me, I'll check and see.
You're going to do that on a daily basis? That's like,
I'd have to get the felony prosecutor to agree to get an urgent date. The grand jury would have to agree to give the prosecutor an urgent date to get the case indicted. I'm not sure at this point. I can send them an email and say that you're requesting that.
I mean, you don't do that.
Okay.
Just,
It is what it is, Your Honor. I don't know.
You just got to be on the lookout. What I would do is probably call a bonding company and let them know, hey, this is my son. Can you just be on the lookout for when it hits and just let us know?
And I'm able to look it up online as well. I mean, it's public information. I see the same.
Yeah,
thing.
I mean, you have to be on a daily basis looking, I'm glad you came.
I think it is taking a toll on him, Your Honor. So I appreciate the court working with us.
I mean, you've done nothing wrong to this point. There's no need to punish when you've done nothing wrong. The best thing you can do is just stay out of trouble.
And he's doing that. He's doing that.
Has he gotten a job or doing anything now? Or
He started the GED program.
great.
He started counseling, so he is doing what you asked him to do. He is doing what I've asked him to do.
How do you feel?
Healthy level of anxiety associated.
It's natural. How do you feel?
Stop buying generic Viagra if you're over 60. You qualify for.
Are you doing well with the classes? Have you been doing it really? In this life, if you put your heart into it, you can achieve anything. That's what's so great about this place. Really. Just you put your heart, soul into anything can happen. Really. That's what this life is about. Making a lot of money and having a lot of knowledge, Mr. Alexander. And it starts in school, in high school. Okay. We'll let you guys go. Just be on the lookout. Your appearance is waived. You guys don't have to come. Just stay in touch with Mr. Elick and he'll tell you how we go further.
That's why he was required to do.
Oh, did we send him for a test?
No, Your Honor. I think he just came, so I don't think.
Yeah, I'd like to send you for a test. I want to make sure you're not using any drugs. Okay. Just hang tight for me now. We'll send you for a test. And then, we'll set you off now. If something comes back and hopefully it doesn't, if it's clean, then we'll set you off or whatever it is. If it's dirty, well, I guess we'll have to deal with it at that point. I hope he's not using, we just don't want you to smoke marijuana. That's it. Okay. All right, guys.
So
We'll
hold
set
off on getting
this right now. No, I want to make sure he's not smoking marijuana. Yeah. Okay. Thank you.
Hand you something? It's just a business card.
Yeah, you can give it to Steven. Sure.
Thank you. Come on.
Thank you, ma'am. The initial bond violation report was filed November 15th of 2024. And the reason was because he was selected to go take a drug and alcohol test on November 11th. He failed to report to do the tests. So he came here yesterday. We had him take a test and he tested positive for alcohol. I ordered you to do one thing. What did I order you not to do? What did I order you not to do?
Not to drink, Your Honor. Not to do drugs. Yes, Your Honor.
There's no excuse. Goes with you.
Could we have a bond on this bond?
Sure. I set the bond at, I was going to set the bond at 5,001.
All right, good. Thank you, Your Honor. Well, get it, people don't, some people don't learn.
So if he does, or when he does bond out, we can talk about further modifications, putting some kind of monitor on him so we know that he's not using.
Well, when he gets out, I'll have him come in.
Yeah, he has to come back. Okay.
All right, sure. Thank you.
Thanks, Ron. Yeah.
I'm sorry, man.
No, it's, 5,001. Mr. Garris. Hey.
See you.
How are you, man?
Johnson on the docket this morning, and so I'm starting a trial in about maybe 20 or 30 minutes.
Yeah, I saw your other half over here. What are y'all doing?
It bothers me that he gets to wear the hat and I don't get to wear it.
And the bottle, right?
But no, it's a DWI trial. In court, yeah.
Okay.
And so,
We have Tammy Johnson?
yes.
What are we doing with Miss Johnson?
Well, it's an old case. I got appointed Friday, and we
Okay.
waited till today. She's not in custody, but she's here. And
She tested positive.
this was a case that had been outstanding for a while. You gave her a second chance and set a PR bond. But she is here.
Right, we asked her not to use.
And I've got good contact with her, and but she's here. And
Come up, ma'am.
Get the discovery in the case and had a chance to do a kind of cursory review. I think the state has done some vetting of it as well, but we're just.
Is she PTI eligible? Do you know?
Well, probably would be, but I haven't had a chance to get that far. It's just been a.
Okay, so, but understand I'm keeping on a very short leash because it's 500 days old.
No, I know, Judge, and
So
as diligent as possible.
please, I'm giving you a chance. You're out in the free world. Most people at this, they wouldn't do it. I would just keep them locked up, He's convinced me to let you out. Make the best of it, Don't use. The only thing I'm asking you to do, don't use alcohol, don't use illegal drugs. And I'm going to test you like crazy. I'm telling you that now. I just took in 2 seconds ago someone into jail because they're drinking alcohol. No means no. No from any source. I don't care what it is. Now, your case, like I said, it's very old. It's time to get on it. So I'm going to give you guys one setting. You need to find out what you want to do. At the next setting, you got to come back. I'm going to give you 30 days, but you got to come back and you have to let me know what you want to do. You must either accept a plea bargain from the state. If you want to apply for the diversion program, you must have the packet done by the next 30 days. Mr. Garris can tell you what that entails, but that is a program that if you're granted entry into and you complete it successfully, the DWI gets dismissed. But you have to apply and then you have to take an evaluation. You got 30 days. Don't use. Do you have a Texas driver license? You're not allowed to drive. The worst possible thing you can do with this short life is get into a car and drive, Ms. Johnson. You already have this affidavit not to drive, so understand that, all right? Okay, guys. Good luck.
Thank you.
Thank you, guys.
I love Judge Fleischier.
When your kid is hurting.
For 2 assaults, and now you've picked up a new case. Can I explain myself? We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On October 15th, 2024, officers were assisting with a stranded motorist disabled in Harris County, Texas, when a witness ran up to the officer and stated that he had been shot at. Witness fell on the ground and the officers observed the defendant running across the street. Witness pointed out the defendant and stated defendant was the one who shot him.
What?
Shot at him.
And he's charged with an evading arrest and an aggravated assault with a deadly weapon?
Sure, Judge, I can look further into the offense report.
Your Honor, on this case, initially, yes, that's what the complainant said, but upon further investigation, the officer could not locate the weapon. And also, he was unsure of whether, based on the offense report, whether the defendant was the one who shot based on location of the complainant, as well as the fact that he couldn't observe the weapon upon retracing the steps of the defendant.
Don't we have shot spotters out there now anyways? What, I mean, you know, it would be interesting to see where this location is, see if there's an actual shot spotter out there. If there is, let's pull the records. You know, it's not rocket science, okay?
So the defendant then began running in the officer's direction. Officers marked patrol vehicle was blocking the lanes with lights activated. Officer yelled at D to stop.
I'm the defendant.
You are the defendant.
Yelled at the defendant to stop and identified himself as police. Defendant turned around and began to run away from the officer. Officer gave chase and yelled again to the defendant, IDing himself and asking the defendant to stop, which the defendant refused, looking back and continued running. Approximate length of chase was 0.6 miles.
Okay. Mr. Richardson, I'm going to find that there's probable cause to go forward with your evading arrest. You have been given multiple bonds. I asked you to do one thing while you were on bond for both of those assault cases. Do you remember?
Stay clean.
And stay out of trouble.
Stay out of trouble. I was shot at.
And now you picked up a new case. I'm revoking your bond. He goes with you.
Revoking my bond?
Mm-hmm.
I was shot.
We're going to look further into the facts.
Please. Are you DeJuan Fairley? Mr. Fairley, you're charged with assault of a family member. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Any witness and the defendant are dating and they have a child. On October 14th, 2024, any witness was driving while the defendant was a passenger and their son was in the rear seat. Defendant began questioning complaining witness because he thought she was cheating, which prompted an argument. Defendant began putting his hands in complaining witness's face, impairing complainant's ability to see the road. Complainant brought the vehicle to an immediate stop. Defendant then began grabbing her left shoulder. While defendant was grabbing her shoulder, complaining witness turned and bit defendant on his hands in an attempt to get defendant to release her. Defendant then punched complainant with a closed fist in the face, causing pain.
All right, Mr. Fairley, I'm going to find that there's probable cause to go forward with your case. Do we know whether she wants to have contact with him?
I believe she does want contact, Judge. It looks like someone from DVD to RIP.
How do you have that belief?
Someone from our domestic
back.
violence division called her, and she said she doesn't want to move forward. So she does want contact with the defendant.
Any other priors that you see?
No criminal history, Judge.
Okay, Mr. Fairley, I'm ordering you as a condition of your bond not to have any threatening or harassing contact with this witness. If I find that you do, I'm going to put you in jail. You will not get any more PR bonds. Do you understand?
Sir.
So I don't know what kind of relationship you have with this person, but if you're someone who's constantly going to fight with this person, be careful. Because remember, it's not what you think as far as threatening or harassing, it's how she perceives. So can conduct in and of itself violate this order? It absolutely can. If I go like this, is that threatening or harassing? It is. And it can land you in jail in a moment's notice. Do you understand?
Sir.
We're going to reset your case to give you time to hire a lawyer. So I will have you come up here. The other thing you need to understand is there's a protective order that is in place. I would get to know it because if you violate the protective order, the state can and will file additional charges against you. And then it gets ugly really quick. You understand? I will have you come up here. Well, we're going to have you sign a court order for you not to have any threatening or harassing contact. I'm also prohibiting you from having any weapons as well. No guns, knife, nothing. I'll have you sign a receipt and we'll get you out of here to hire a lawyer. All right? Do not leave until you sign our bond conditions. Otherwise, I'll issue a warrant. please.
Never sue the other driver after a car accident. There's a better way to get paid a way bigger check without.
Is it DeTwain Johnson? DeTwain. Mr. Johnson, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right.
2 assaults already, and now another case while on bond? That's not just bad luck, it's testing the court's patience. Remember, bond is a privilege, not a free pass. Question for you, should repeat offenders lose bond rights automatically?
Have an attorney present if you cannot afford one. One will be appointed to you, sir.
On October 16th, 2024, officers conducted a traffic stop in Harris County, Texas on a silver Buick bearing a Texas temp tag with no return to a motor vehicle, no light, and not sure what that means. But he had a temp tag that did not return to a vehicle and no lights in the back. So the defendant exited from the driver's side of the motor vehicle, leaving the vehicle on, and walked towards the patrol motor vehicle quickly. Defendant attempted to walk back towards the driver's side to turn off the motor vehicle. Officers stopped defendant before he opened the door. Defendant stated the firearm was inside the vehicle. Officers opened the driver's side door and observed a Glock in plain view, unholstered, and in the driver's side door panel.
Find that there's probable cause to go forward with the case. Do you have a valid Texas driver license?
No, sir, I have an ID, a state ID.
Not allowed to drive. I'm making that a condition of your bond, and you will be signing an affidavit with me today promising you're not going to drive. If you get a Texas driver license and liability insurance, I will let you drive. But until that point, if I find that you drive, I will have a contempt hearing. You'll be facing an additional 6 months and a $500 fine every time you drive. Do you understand?
I had insurance on my car though. They
don't have a license. You need a license, a Texas driver's license.
Oh, yes, sir.
Until you have a license, you can't drive. I'm glad that you have insurance because that's really one of the most important parts. Because if you get into an accident and create $50,000 in damage, if you don't have insurance, they're going to come after you and make you pay the 50 grand.
Yes, sir.
Have insurance, and if you get into an accident, they'll even give you a lawyer to represent you. But you still need a license. If you get a license, come back and show me, and then I'll take this off. But until that point, don't. We're going to reset your case to give you time to hire a lawyer. So I'm going to have you come up here, swear to us that you're not going to drive, not be in possession of any weapons, and after that, we'll let you go. What do you do for a living?
I work for landscaping and mulching.
And how much money do you make a month?
Oh, my father. Work for like 25. It'd be like 25.
A month?
It's not that much, you know.
This is 2,500 is not bad. I mean, who do you live with? Where? Do you live by yourself in the apartment or who with?
Just me.
Do you have children?
Yes, sir. I have a daughter.
Where's the kid now? Do you provide support for the child? I'll have you fill out an application. I'll take a look at it to see whether you qualify. I need to know everything about you, what kind of car you have, how much money you have in the bank.
I don't have a bank account, Bill.
Oh, you don't put all zeros? Because if you do that, I'm going to send it right back to you. I need to know everything about you, monetary, financial, everything. Do you understand? We'll have you come up here, swear to this, and then they'll give you an application, fill it out, and I'll take a look, okay? All right.
Does you also have a Spanish arraignment?
Ay, caramba, la bamba. Come on, man.
Page 10, Gutierrez.
Come on, Luis. Okay, yeah. Said page what?
10?
Israel Gutierrez. Yes. Mr. Gutierrez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On October 15, 2024, officers observed defendant's motor vehicle exit a parking lot and drive into the main roadway very suddenly with rapid acceleration. Officers saw that the vehicle had a defective license plate light and expired registration. After officers stopped the vehicle and made contact with the defendant, officers observed the defendant to be wearing no shirt, had unbuttoned pants on, a strong odor of alcohol in his breath, and glassy eyes. Defendant was leaning on his car for support when asked to step out. Defendant admitted to drinking. SFSTs were conducted. 6 out of 6 HGN, 4 out of 8 walk and turn, and 2 out of 4 one-leg stand. DICs were read, but breath was refused, and a blood warrant was signed and executed.
Any prejudice?
No, Judge.
Mr. Gutierrez, I'm going to find that there's probable cause to go forward to the case. Do you have a valid Texas driver license? Are you a United States citizen? Are you in this country with or without permission? You're a citizen? Do you have liability insurance in your name? Okay, as long as you have both, you can continue to drive. I am ordering you not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming alcohol or drugs, I'm going to put you in jail. You will not get any more PR bonds.
Look at how the case pivots here, from evidence to background details. Judges often dig deeper to understand the bigger picture. Is this just one mistake or a pattern? Audience, what do you think matters more, the crime itself or the person's history?
Do you understand? Can you run his license for me, please? We're going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Victoria real quick, sign a reset. You'll get with pre-trial for your bond conditions, and after that, you'll be free to go. When you come back, please have a lawyer. And I'm going to tell you this now, that don't take your time waiting for a lawyer because you're only hurting yourself. There's a lot of timing requirements with the DWI, and it could really hurt you if you just sit there and wait. Okay? That's okay. Please. Okay. Great. Thank you. Okay, Robert, let's go.
Coach, ready, coach? COJ. Sí, señor, no, señor.
Are you Coach Tambariz Franklin Abraham?
Yes, sir.
Charged with driving while intoxicated, you're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement. They're offering you 3 days in jail, credit for the 2 days that you have served. You need to understand, after today, this DWI will go on your record. If you were ever pulled over, an officer will see a prior DWI. If you smell like alcohol or dope, they're going to arrest you, put you in jail. What we're doing today, from now on, you're facing a minimum of 90 days in jail. So if you're not in this country with permission and you go to jail for that kind of time, I can all but guarantee an immigration detainment. So if I were you, I would never get in a car, even if you've had a sip of alcohol. Do you understand?
Yes, sir.
You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen or a possible immigration consequence, you can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you cannot change this. It will go on your record and you can never take it off. Is this what you want to do?
Yes, sir.
Is it true or untrue that you had a 0.15 or above?
So you think you know Wix, but do you really?
Yes.
Okay, so true to the enhancement. All right, sir. How do you plead, guilty or not guilty? I will find you guilty, send you to 3 days in jail. I will give you credit for the 2 days that you've done. I'm going to suspend your license for 90 days. Do not drive. Your license is now suspended. Do you understand? If you drive, you're going to be right back over here, and it's not going to go well for you. All right. Good luck.
She makes between $500 and $600 a week, supports an elderly mother. He doesn't have much money. Can you waive the state traffic fine, Judge, on that?
Doesn't have any savings, no bonds, no stocks.
I want you to understand something, Mr. Costambre, that your lawyer is asking me to waive the fines and fees for you. We'll do that as a courtesy. Now, I'm now taking away around $500 to about $4,000 in fines and fees. It will not happen again. You come back here with the DWI, it's going to be at least $6,000 to $7,000 that you will be responsible for. So, out there, come back here with another DWI. It's really going to go sideways for you. Do you understand?
Yes, sir.
Okay. All right.
Thank you very much, Judge. Thank you.
It's okay. Ricardo, what do you got real quick?
Judge, if I can approach real fast. Oh.
Okay, what's the name?
Freddie Ruiz, Judge?
Freddie Ruiz.
Yes.
Mr. Ruiz, you're charged with racing on a highway. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On October 15th, 2024, officers observed two motor vehicles traveling at a high rate of speed on the 3100 block of Blalock Road in Harris County, Texas. Officers observed both motor vehicles line up at a red light and both motor vehicles traveling at a high rate of speed side by side. Officers caught up with motor vehicles and initiated traffic stop. Officer made contact with the defendant. Defendant stated he was going home from work. The other driver swerved into his lane as he was attempting to strike the defendant's vehicle.
What?
And then the defendant decided to do the same thing to the other vehicle.
So they're like demolition derby?
I know what it sounds like, Judge. And they both started traveling at a high rate of speed after that.
What does a high rate of speed mean?
I'm gonna check the offense report and see if we have the exact speed.
And he makes an admission that they're racing?
He makes the admission that he was doing the same thing to the other vehicle that the other vehicle did, where the other vehicle was attempting to hit him.
And do we have a co-defendant as well?
I don't see one listed, Judge.
And here comes the decision, a guilty plea. 3 days in jail might sound light, but the conviction follows forever. Jobs, travel, even housing can be affected.
That's fine. I just wanted to go check on this still okay.
Percolating, No.
It doesn't look like the officer provided the exact speed that they got to in the offense report or in the hymns. He just says high rate.
Racing again? Other than the demolition derby?
So the officer observed them, driving together, and then I believe he pulled the defendant over, and then had to call in a Spanish-speaking unit. And then, so the defendant stated that he was traveling home from work, and just that the defendant swerved into his lane trying to strike his vehicle, or sorry, not the defendant, the other driver swerved into his lane trying to strike his vehicle. And then the defendant decided to do the same thing.
I get it, and it could be a deadly conduct, but where's the racing? Read it again, read it again. I mean, maybe I missed it, but.
So, yeah, the officers observed them traveling at a high rate of speed. Again, we don't know what speed. He watched them both line up at a red light and then going side by side at a high rate of speed. And that's what the officer.
See it like in a competitive manner.
Right.
Then that's racing.
So that's what the officer observed, and then once he pulled the defendant over, that's where the officer learned that the other driver, according to the defendant, had tried to hit the defendant, and the defendant tried to hit him back.
So they're at a red light. They both take off at the same time at a high rate of speed.
Right, and the officer pulls over the defendant's car.
All right. Mr. Ruiz, I'm going to find that there's probable cause to go forward with your case. This is the second time that we have an incident like this with you. So I am taking away your privilege to drive. You are not allowed to drive at all. And you will be signing an affidavit with me today, promising me that you're not going to drive. If I find that you do, I will have a contempt of court hearing. You'll be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? Do not drive. Do you understand?
Well, I basically bought this roof.
Yes, sir.
You will be facing a lot of time in jail if you do. Heed my warning, because every time you come back, I'm going to pull your record to see if you're driving or not. You have a lawyer. They will take care of you. I will waive your appearance, but it is your responsibility to stay in touch with them. And they will tell you when you have to come back to court. If they tell me they can't get a hold of you because you're playing games, I will issue a warrant for your arrest. You pick up a new case or start acting a fool in the free world, we will not give you any more PR bonds. Do you understand, Mr. Ruiz?
Judge.
Okay, all right.
Just quickly, this is the second time he's been.
He has a prior evading arrest in a motor vehicle, and now we have a racing case. I don't want him in a car. That's it.
Understand, Judge.
That way.
Can you turn the bond conditions up?
Yeah, Ricardo. Ms. Hernandez.
Yes, Hernandez. How are you?
You're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Please don't say anything.
On August 18th, 2023, the defendant issued a check for $1,577 as a payment for vehicle registration. The bank returned the check saying that there were insufficient funds. Complaining witnesses provided a copy of the demand letter sent to the defendant, no response.
Got it. All right, I'm going to find that there's probable cause to go forward with the case. You need a lawyer to represent you in this case. This is a theft by check, and it can have dire consequences on your, going forward. We're going to reset your case to give you time to hire a lawyer. So I'm not going to put any conditions on your bond. Just be careful. Don't pick up any new cases. We'll just have you sign a reset and we'll get you out of here. When you come back, please have a lawyer. Okay? Please.
Hola, caballero, buenos días. Pase aquí, por favor. Son declaraciones, ¿cierto? Hágase aquí, hermanito. Venga, hermanito, buenos días. Parece aquí en el centro. Solamente miren los jueces. Solamente miren el juez, perdón, y le contestan nada más en español, señores. ¿Cuál es su apellido? Martínez. ¿Martínez? ¿Y el tuyo? Gutiérrez. Gutiérrez.
And who's the other guy?
Para adelante.
Where is Martinez?
I will. Martínez.
I don't see it.
These folks go to use it for it? Neither. Okay. Be glad. Is it under Martinez? Okay. Well, you can always call me for help if you need. Professional, very. No.
All right, gentlemen, good morning.
Yes.
Both of you guys are charged with criminal offenses. Both of you guys have worked out agreements to take care of your cases today. I want you to understand both of you guys will now end up with convictions on your record. If you ever come into contact with police again and you have the smell of alcohol, you have the smell of dope, and they come into contact with you, they're going to look at your record. If you're in a car driving, they're going to see your intoxication case, and things will probably not go well. Both of you need to understand that from now on, each of you are now facing at least 30 days in jail. This is a theft.
That's correct, Your Honor.
You are now charged, you're charged with theft. Didn't want to do anything else.
No quería hacer nada más en este caso. No, señoría.
Understand that this theft is going to go on your record. It's an enhanceable offense. If you continue to pick up theft cases, they can charge you with a felony offense. And then you were looking at days instead of years. Do you understand? You are charged with boating while intoxicated. You ever get into a car, get pulled over, smell like alcohol, you will now be facing a minimum of 30 days in jail from now on. Both of you, if you do any kind of substantial time in jail and you're not here with permission in this country, you're going to get an ICE detainer. So don't act like a fool when you're out there so that this doesn't happen. It's not hard. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, you can never change this. Is this what you guys want to do?
Eso es lo que ustedes desean hacer. Sí, tiene que hablar. En su caso de embarcación o estar en una embarcación intoxicado, ¿cómo se declara? Culpable. Guilty.
I will find you guilty, send you to 3 days in jail. I'll give you credit for the 2 days that you've done. I'm going to suspend your license for 90 days. Do not drive. Otherwise, you will be right back in here, and it's not going to go well. Do you understand?
Yes.
Charged with theft, you're facing up to 6 months in jail. You've worked out an agreement, 3 days in jail, credit for the 6 that you've done. This is how you understand it. How do you plead to this offense, sir? Guilty or not guilty? Is this from a Walmart?
Home Depot.
Your picture now resides in Home Depot. Anytime you walk into a Home Depot, your picture sits on a wall with everybody else who's been convicted of this offense. So just know, the minute you walk into a Home Depot, if they see you, they're going to call the cops. Do you understand? All right. I will find both of you guys guilty, send it to you the agreement. Good luck to both.
Thank you.
So what does he do for a living? What do you do for a living?
Roofing.
How much money do you make a month? Be honest, because you're talking to me in court.
Around 5,000.
You will be required to pay the fines and fees for the surcharges, sir. So if you don't pay it, you will go to jail. I will give you at least 2 years to pay this, so it'll cost you around 100 to 120 bucks a month. But understand, you now will owe quite a bit of money. If you fail to pay it.
For the defense, Andrew Salinas, Salinas.
All right. And we're here now due to Mr. Kabir having a bond violation. This is our third bond violation report that we have had. Our first bond violation. So I guess let me start up. Mr. Kabir is charged with driving while intoxicated. He was ordered as a condition of his bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. Sir, I'm up here. I'm not on the floor. Up more. Look at me. You're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during any questions and interviews of the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir.
On July 4th at 3:49 a.m., officers observed a vehicle in a moving lane of traffic sitting idle with damage to the front passenger tire. The defendant was sitting in the driver's seat, slumped over in asleep. Officers woke the defendant and he exited the vehicle. He had red, bloodshot eyes, slurred speech, and unsteady balance. Standard field sobriety test was conducted, and a 6 of 6 on the HGN, 4 of 8 on the walk and turn, and 0 of 4 on the one leg stand. The defendant refused a breath sample, and blood warrant was obtained, and a blood sample was taken.
Are you on something now, Mr. Kabir?
No, Your Honor. I'm not.
How old are you, sir?
26.
What do you do for a living?
I'm the owner of a healthcare consulting firm.
Are we able to go send someone now, Tracy?
No.
Mr. Kabir, if you have a drug or alcohol problem, you better address it. Because if you don't, and I see it becomes an issue, I'm going to address it for you. I promise you're not going to like the way that I do it. Do you understand?
Yes, Your Honor. May I?
Don't. The only thing I want to impart to you that the drugs and alcohol stop now. I'm making it a condition of your bond not to consume alcohol or any illegal drugs. Do you understand?
Yes, Your Honor.
I'm going to randomly test you. If I find that you're consuming, I will revoke your bond and put you in jail. If it becomes a repeated issue, I will put you in a rehab facility. I don't want to have to do that. My only concern is public safety. Do not drive if you don't have a license, and don't consume anything. Do you have a Texas driver license? Do you have valid liability insurance? Okay, we're going to reset your case to give you time to hire a lawyer.
There is a prior DWI from June of this year in Navarro County.
Okay. I'm ordering you now not to drive any vehicle that's not equipped with an ignition interlock. Are you currently on probation or parole or any kind of, for a DWI now?
No.
What's the status of that DWI? Do you have an open DWI right now?
No.
Okay. I'm now going to put a condition on your bond that you're not allowed to be out past 9 p.m. to 6 a.m. I'm going to put a GPS monitor on you, so I know that you're not out in the middle of the night. Unfortunately, because of the hurricane, we're not allowed to have people tested right now and I think that you're on something now, Mr. Kabir.
I have bipolar and schizoaffective disorder. I have bipolar and...
Then alcohol is not helping the issue, Mr. Kabir. It's only going to exacerbate anything. No more. Do you understand?
Yes, Your Honor, at this time, I'm not on any substances. I take multiple medications for my mental health issues, but I'm not on any unlawful or illegal substances. I'm only on prescribed medications.
Okay. No more alcohol. Do you understand?
Yes.
No smoking marijuana. If I test you for marijuana, are you going to test positive? Okay. Don't. So GPS with a 9 p.m. curfew for now until we know that he's not out and about in the middle of the night. I'm going to have you now go to the jury. We're going to have you sign a reset. After that, I will have you take your seat in the jury box, and then we'll be back with you shortly, Mr. Kabir. Okay, how's this? I put defendant must find full-time employment. Why are you trying to leave?
Sir, I was not trying to leave. I just need to use the restroom, so I wanted to request and ask the officer. I didn't want to disturb you while you're in the middle of session.
Right. Don't disturb me, and you just can't walk out. You have to ask for permission. When you walk out, we issue warrants. Do you understand?
I wasn't looking to walk out whatsoever.
Okay. So tell me, you said you own a business. What do you do exactly?
We help treatment centers, or we specialize in bringing in new patients into healthcare treatment centers, specifically alcohol and opioid addiction treatment centers.
You have a monthly income from this.
Yes, Your Honor.
How much money do you make a month?
Well, right now, the business is still in a growth stage, so we revenue, but I don't take personal income. I take a small amount of personal income, so you can say $2,000 to $3,000 per month as of current.
Where do you live?
At my parents' house.
Yet you drive a BMW.
Yes, Your Honor. The revenues of the business are over that amount.
Okay, so you need a lawyer to represent you in this. And it would behoove you to get one really, really quick, because one of the conditions on your other DWI is don't get in trouble and probably not to consume alcohol. Once this other jurisdiction learns of your new DWI, they'll probably going to issue another warrant for your arrest. So you need a lawyer to represent you, and quick. So we're going to let you go today. And I'm telling you, no alcohol.
Yes, Your Honor.
You have an interlock that you're going to, within 3 days, you must get an interlock on your car. If I find that you have not put an interlock on your car, I'm going to put you in jail. And I'm going to tell you, with 2 open DWIs, I usually put bonds at around $25,000 in that time. So beware. You're you're skirting extremely thin ice at this point. Do you understand?
Yes, Your Honor. I will contact the interlock immediately. I have the information for it, but I don't know exactly the date that they'll be able to install it.
You must get it done within 3 days.
What if the company's not available to do it within those 3 days?
Well, then come back and let us know. Okay. but I'm not going to entertain any excuses. You also need a lawyer to represent you. So get on that as well. As soon as you leave here, start researching that as well. State, does he have a DWI open elsewhere to refresh my memory, please? Mr. Salinas, did he not have a DWI?
He currently, yes, Your Honor,
He has an open DWI where?
in Navarro County.
So we put conditions on him. I can't. Please, Felicia,
The most recent ones, Judge, or there's been a few that we've amended over time.
what are the current conditions now?
The current conditions now are appear in court every time the case is set on docket, there's no new law violations. Install a IID device in the vehicle, no driving without permission of the court, no drugs, no alcohol. Plan to obtain a SCRAM device, and to submit to drug and alcohol testing at the court's discretion.
Did he have a curfew as well?
No, Judge.
He originally had a curfew, Your Honor, but because there were no issues with that, we had it removed.
Okay.
Yes.
And so now our first bond violation report that we had was September 23rd, 2024. And in that one, he had been in lockout for failure, I guess, to pay. I don't know, which is weird because we normally always pay for all of them. A second bond violation report was filed January 6th, 2025. Where I guess he was in lockout again because due to no recalibration of the device. And we now, February 4th, 2025, have a third bond violation. And in this violation, the defendant was ordered to obtain a SCRAM device and to refrain from alcohol consumption and not tampering with the device. The defendant's SCRAM device has reported one consumption event that occurred on January 16th of 2025 at 11:55 p.m. It was also confirmed by a SCRAM analyst as well. Correct?
Yes, Judge.
Okay, so.
Yes, Your Honor. So, yes. So to begin with the first amended order for pretrial, so if the state wants a copy, I have a copy to show them, but sure. So, Your Honor, just going to the very first order, as Your Honor just noted, usually agency fees are waived for that. However, the box on that for saying that the fees were waived, I believe, were not checked on that. Further, Your Honor, the main purpose here for your determination of giving someone bond in the first place is to establish that they come back to court. So are they a flight risk? And then also, are they a dangerous community? Now, Your Honor, if an interlock device is in lockout on a vehicle, it doesn't start. No one's driving that vehicle specifically. There's no way that they can. I could call a witness to testify that, but I know that you
But that doesn't
are aware of
excuse you
that.
from violating the conditions.
Your Honor,
Are you justifying that because of that you can just?
No, Your Honor, I'm trying to contextualize this because we've been here two prior settings before. I know you've concerned greatly about the number that it's at number 3 now. I'm trying to establish that the first and second, there was no indication of alcohol consumption or drug use during that time.
It wasn't working. How are we supposed to know?
And Your Honor, one of the two main points of determining what kind of bond, both the conditions and amount are, will they return to court and community safety? Here, my client who's being accused of DWI wasn't driving that vehicle. So it was impossible for him to be driving that vehicle, Your Honor. So I ask you to take that into account as far as public safety goes. As far as this latest bond violation, it's the state's burden to prove that my client violated his bond. All we have right now is a report by Scram, but no one is here to testify on behalf of. We can call that, Your Honor, but sure.
Judge, I spoke with the defense counsel today and he said that he was not requesting to have anybody come here to testify to the scram device.
We have Felicia that can be called up as a witness to testify as to what happened with and whether he tested positive or not, whether he's consuming alcohol.
It's also the state's burden to prove that he did that. So that's, yeah.
Please.
Yes, Your Honor, we would call pretrial services, Ms. Felicia Charles.
Okay, ma'am, would you please come up, raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay,
So you have first amended order and then second, third amended pretrial supervisions and then the fourth. So referencing the fourth amended order for pretrial supervision and bond conditions, I'm showing you, do you recognize this? Yes. Can you tell us what this is and what are the conditions that are checked? These are,
Sorry, could you repeat it?
sorry, I said I don't know if she needs that. It was an extra paper.
Okay. I just want it on the record.
Sorry.
That's all right.
Yes, these are pretrial bond conditions, and these are listed as appear in court every time the case is set on docket unless the judge waives appearance. No new law violations, install ignition interlock within the vehicle, no driving without permission of the court, no drugs, no alcohol, and then to obtain, we do have a curfew of 9 p.m. to 6 a.m. and then a scram device to be installed. And so what we're showing you is what's been marked as State's Exhibit 1, and we'll tender this to defense for any objections.
No objections.
admitted as one.
So in this case regarding the scram device, can you tell us about that?
Yes, so what exactly about?
What is that? What's the standard procedure someone's supposed to do?
Yeah, so a scram device is ordered and it tracks the
Objection, Your Honor. The foundation, I believe the state is trying to ask her to testify as far as her, are you trying to establish her as like an expert on scram?
And I was not trying to establish her as an expert, just from her experience, what the scram device is basically for, which she can testify to as trial.
I'd ask that the court consider that as that testimony as a layperson, not as for the purposes of establishing expertise.
So I want to know whether there's a violation for alcohol consumption. So, what day do we have any kind of hot blows? What's the amount? Do you have anything of that nature?
Yes, so the report should have been provided to the bond violation email as well of the graph.
And I'm showing her now what's marked as state's exclusive.
For the exact amounts and everything, I would need to look at the report that was provided in the email.
Okay, please.
Have the graphs been printed, state, or she's just referring? Yeah, just so we can all agree on what she's referring to.
And I'm showing you what we marked as state's exhibit 6. Can you please tell us what this is?
So this is a scram report sent back to us whenever the device information and data is pulled. And this is what the analysts observe for either tampers or consumption. And this is what they send us back if there is a confirmed tamper or consumption as per.
Okay, so this fairly accurately depicts a scram for anybody that says it. Yes. We will tender defense for any objections and note that this has been, is it correct to say this has been emailed to defense prior to this date?
Yes.
Defense proceeded, no objection, Your Honor.
Okay, it'll be admitted.
Okay, so can you tell us about the specific dates in this report again that was given to defense prior to today of the basic dates that the scram was not completed properly?
Yes, so the device seems to be fully functioning. And on January 17th, Friday, January 17th, the scram device picked up a peak TAC of 0.078%. And then established a zero baseline once again for the dissipation rates of the alcohol at 9:05 a.m. on January 17th.
Say it again.
9:05 a.m., January 17th, 0% THC was reestablished for the dissipation of alcohol.
Okay, and for those dates, the ones that match on what I'm showing you is State's Exhibit 2, the bond violation report. Can you please do references?
Yes.
Can you please read the details of the violations here?
It says the defendant was ordered to obtain a scram device and to refrain from alcohol consumption and not tampering with the device. The defendant's scram device has reported one consumption event. The confirmed alcohol consumption occurred on January 16, 2025 at 11:55 p.m. This information was received on 1/17/2025 and confirmed by a scram analyst.
Thank you. We pass the witness.
Okay.
All right. Good morning. I just want to, if you could turn to, I believe it was the State's Exhibit 3, I think, for the SCRAM non-compliance report, the cover page. Do you see that? Yeah, what she has right there. Oh, is it 6? Okay. Would you stay, since you're close, would you give that to her? Thank you. So just looking at the cover page there, can you read who the agent is on this report?
Justice Turner.
Are you Justice Turner?
No.
Have you consulted with Ms. Turner about this report?
Through the emails, yes, for the bond violation report and the.
What exactly did those conversations include?
The entire.
So let me. Sorry, that was a poorly phrased question.
I'm sorry,
No,
I don't understand.
that's my fault. Don't worry about it. My question is, did she consult with you when compiling this report?
Would you be more specific?
Did you help in the assembly of this report?
No.
Okay. Have you ever assisted or aided in the assembly of a SCRAM systems non-compliance report?
No, no one.
No, no one in the department does. Okay. And do you have any sort of, have you ever worked for SCRAM systems?
No.
Have you ever had any special training in SCRAM systems?
Yes.
What is that training?
I actually met with Ronald Grant from Sentinel, the regional representative, about maybe 2 months ago to get an advanced knowledge of this device. This is one of the very few devices that I do have advanced knowledge in, but not expertise.
Sure. And what exactly did this person teach you?
We went
Briefly.
through how to read the graph, kind of how to establish consumption versus a tamper, environmental factors versus consumption, et cetera.
Okay. So during that training, did you ever actually look at a physical device, the SCRAM device?
No.
So you didn't do any live experiments where, for instance, you put on a SCRAM and then, drank alcohol to see how that works?
No.
No. Okay. And as far as Mr. Kabir's SCRAM device, have you examined it prior to this hearing?
Me personally, no.
Okay. And so is it fair to say that you've been thoroughly trained on the theory of SCRAM device and alcohol detection? Is that fair to say? That you're, let me rephrase that. So you don't have any actual technical experience with how the SCRAM device detects alcohol in someone's skin. Is that fair to say?
Thank you.
I don't want you to think. It's a yes or no.
I still don't understand.
I'm trying to understand too.
Do I not understand how a SCRAM device works, or have I not for myself? And
Sure. So, this is pretty, is it fair to say the science is kind of advanced here? When you received your training, did you have the personal opinion that was advanced science that you were learning about?
I believe so.
Okay. And you don't, so basically it sounds like your training, and correct me if I'm wrong here, your training was mostly so you could be able to make sense of what a report says and not necessarily how the actual device itself works. Is that fair to say?
Partially, yes.
Okay. What's what am I partially wrong about?
Yes, reading the graphs, but then also what kind of would entail, what would mess with the device.
Okay.
Essentially, as well with tampers. environmental factors with that, makeup or, placing something between the skin, how things are worked around with the device, how people evade from, having the correct reading on the device.
Sure. And so that's, you basically learned that all in theory, right? There were no withdraw that question. So I'm just saying there was no actual, you didn't look at any studies. Did you read any studies when you did this? Okay.
I actually met with him due to another case. I wanted to further understand it, so we examined the report for that.
Well,
and also reviewed some of the peer-reviewed articles.
Well, that's great. I'm glad that you want to, a lot of people won't. They'll just kind of do their jobs, right? I'm glad that you want to further knowledge, but what I'm trying to get at is it's fair to say that knowing how something works in theory and actually examining the actual thing itself, the practicality of it is different, right? Do you agree with that statement?
Yes.
Okay, so without actually having examined in your own personal observation, how a scram device detects alcohol in someone's system, it seems that, is this fair to say that you're very, very well versed on theory, which is probably more than some other people, but not necessarily on the practicality of detection?
Question asked and answered.
Okay, just let's go.
All right. Just answer the question. I don't know if that was an objection or sustained or overruled.
Let's just move on. I mean, we're here to see, is there a positive blow or not? She's testifying that there was.
Sure. I'm just saying that this, I'll make my argument in closing. I don't have any further questions. Thank you.
Okay, closing, or wait, hold on. Anything further from the witness?
Two very quick questions, Your Honor. So do you get notifications if the scram device has been tampered with? Yes. We get notified of tampers and consumption events. And you get notifications if it's been cut off? Just what's been going on with the scram device? You get those notifications? Yes. Okay, thank you. No further questions.
Matt?
No further questions, Your Honor.
Okay, thank you so much. Okay, argument.
So, Your Honor, this is a pretty basic, simple case. The bond violation report is evidence the defendant was ordered to obtain a scram device and to refrain from alcohol consumption and not tampering with the device. The defendant's scram device was reported on one consumption event. This happened January 16th of this year at 11:55 p.m. and this information was received on January 17th of this year at 5:18 a.m. And clearly, there were up to 4 amended orders for pretrial supervision and bond conditions. It was obvious which the defendant was supposed to do, and he directly violated those orders, as evident by the pretrial services and bond violation report. So it's pretty clear here that we would be asking to revoke bonds in this case.
And we would just like to urge that this is a fair and convincing standard, as I already know, Judge, and it's not beyond a reasonable doubt. I don't think that we need a scientist here to prove that the scram device is a device that can be detected.
Okay.
Yeah, Your Honor, I agree with State insofar as this is a simple matter. Where we disagree is, I think a scientist was needed. I think someone who actually has the technical know-how of how this violation report came to be. The state did have that standard of clear and convincing to prove that my client violated this. So far, all we have is a piece of paper that is, at least for right now, is supposed to have been prepared by someone else who is not here to testify. There's no ability to cross-examine them on their expertise, on any notions of false positives, on any issues that a technical expert would actually know about the device. And without that, Your Honor, I think it's very clear that the state failed to prove their burden of proof that my client consumed alcohol. And I would ask that, Your Honor, again, not revoke the bond, keep it as is. My client's here. There hasn't been any warrants for his arrest issued since he's been coming to this court. And in the allegations itself of the underlying offense, there is no allegations of injuries or accident to persons. So again, just take into account that you need to take into consideration flight risk and safety of the community. Nothing that's been established here in this hearing or outside of this hearing should lead the court to believe that my client is a flight risk or a danger to the community. And with that, I'd ask that you not revoke the bond, Your Honor.
And Judge, these devices are used.
Say it again.
These devices are used all the time.
Well, their use all the time is
Just so-
irrelevant to needing an expert to testify on that.
Absolutely. I absolutely appreciate your tenacity. I have done everything in my power not to revoke his bond. He is on bond for a DWI in another county. He picked up a DWI here. He's had not one violation. On the first violation, I didn't take him in. He had a second violation. I didn't take him in. Now he has a third violation. It would be unreasonable for me not to. I told you that there was no tolerance in this case. You yet refuse to comply with bond conditions. I find by clear and convincing evidence that you refuse to comply with bond conditions, and I have bent over backwards not to put you into custody. But now we have a positive blow. We have someone who has testified to it, and I believe it. So I am now revoking your bond. He goes with you.
We have the positive THC or stuff.
He had a positive THC, right?
Yeah,
As well.
that we sent him earlier this week.
He also tested positive for
THC.
marijuana as well.
Well, Your Honor,
Yeah, this week.
that wasn't, are we still on the record then? On that? Okay. Well, I would also want someone to come testify about that, Your Honor, but you know, that I'll make, I know, but I know you already made your ruling, but I was ready to testify on that because they don't have anything on chain of custody on the test itself, on whether it tests cannabinoids, which Delta 8, hemp. There are a bunch of things that are THC related that could pop positive for THC that aren't THC.
Regardless, we admonish him not to put anything in his body that doesn't have any Delta whatever. Regardless, it's number 3, goes with you. Off the record. Sorry. Thank you. But I just can't, with an open DWI and a third, that's it. I can't just keep doing it. You know, at some point I become an enabler and I can't do that. I can't keep doing it, you know? So.
Well, I mean, Your Honor, I understand you're revoked the bond. Would you consider raising it to?
Well, I am going to raise it, right? I'm going to raise it to 7503 now.
Well, and look, I'll just, if you could take this into account, Your Honor. This is a hired client. You know, he has every intention of taking this case to trial. So I would, you know, just, I'm not cheap, Your Honor. So if you could keep that into consideration on that.
It's, you know, and it's.
I understand.
Representing him in Navarro too?
No, I'm in touch with his counsel there, but no, I'm not representing him there. Yeah.
But tell him this, that he's lucky that he didn't revoke him on the first 2 cases, considering that he has an open, you know, really, because, and I'm telling you now, I don't know how I didn't, but I can't just keep doing it. I can't. 7503. Yeah.
Judge, quick on this one. I should have called her up. She failed to appear on her.
Just don't worry about it instead.
All right, page 14. Page.
And then hold on, I have a lawyer here, Mr.
Oh, yeah.
Middleman Meltdown is a yearly streaming-based fundraising event where we cook metal meals.
Well, that's it for today, everybody. I will see you guys tomorrow, as I am very busy right now trying to get this new channel set up and running. So you all have a wonderful evening. Ta-ta and ciao. I will see you again tomorrow at 3:00 p.m. Have a wonderful evening.
solid ground, always drawing near. Never give up on this heart of mine. Put it back together every single time. To all you do from the highest peak, I can see it through with your care and touch, everything's okay.